Don Hammond, Esquire. How the hell are you?
I'm doing great, Jeff, here in my home office, safely sequestered. I did manage to make it to court a few times this week, but mostly staying home.
Wow. And what's it like in the courthouses? Is it pretty barren, or is it bustling with activity?
It's pretty barren. The courthouses and courtrooms are mostly closed. The few that are open seem, you know, it's a little light for the few that are open. But everything that's happening in the courts is happening in these few courtrooms. So it's far from just empty.
And are they doing the whole social distancing thing and wearing masks and anything like that?
Everyone is wearing masks. They are requiring, like my clients, if they're not in custody, are waiting out in the hallway until their case is called. And they have signs up that say like one person per bench in the courthouse hallway. So they're trying to enforce it that way. The attorneys, prosecutors, and everybody are all wearing masks.
What about the judges?
Judges I'm seeing some variation in whether they're wearing their masks.
That's like Trump at the press conferences. He won't wear the mask because it doesn't look cool.
Right. Well, they're up on the bench and there's nobody really within 6 feet of them while they're up there. So, and there's nobody directly in front of them in the well for, probably 15 feet or something back to the attorney tables.
Well, also there's a need to hear them too. I mean, are they pretty well mic'd in the courtrooms?
Generally, no. There's
poorly
a
mic'd or
reporter
not
there.
mic'd at all?
They're usually not mic'd.
They should be. What's the matter with these people?
Right. So there are some courtrooms where there are microphones, some of the larger courtrooms. And there's actually one courtroom I'm in sometimes out in Lancaster where everybody sits in sort of a glass room that's separate from the actual courtroom. So the judge has to turn on his mic and then he's broadcast into that separate room.
Right. But even if you're in the same room, it should be amplified because the spectators should be able to hear too, right?
I think most judges speak loudly enough that it's not necessary. And of course, the spectators should be able.
There's the witnesses and the lawyers too. In other words, not every single person is going to speak loudly.
Right.
You got to put me in charge of the justice system, Don. I'll spend it on a week.
Of course we should, Jeff. But yeah, I mean, they should be able to hear me and the prosecutor and everybody else in the courtroom too, but none of us are really mic'd. Right. There are often microphones in the courtroom, but so far as I can tell, they're not on. I've never heard my voice actually get amplified in a courtroom.
Right. All right, well, let's talk about this case that you brought to my attention. Now, sometimes something I find interesting, I say, hey, Dan, what about this? And you say, yay or nay. This time, you brought it to my attention, something that you wanted to talk about. And I want to keep things fresh, so I didn't even ask you what your opinion is about this. So I'm pretty curious to hear what it is. This is the story I'm talking about is Facebook has instituted a policy in which they ban event announcements when it's in violation of a state's stay-at-home orders. And you said you wanted to talk about it, presumably because something about it has got your craw. And what is it, Donald?
Well, I certainly think it's interesting that Facebook is essentially taking a side on what amounts to, I mean, it's a public health issue, but it amounts largely to a political issue. And for Facebook to decide to censor political speech is fascinating to me that they would do that. I mean, I would certainly support people's First Amendment right to, make posts about what's going on in the community and to, exercise their First Amendment right if they want to go protest. And then it's up to the government under the various orders if they want to go break up the protest and arrest people, and then we'll, test it in the courts. But I don't think it's Facebook's job to censor people. I think it's fascinating that they've chosen to do that. And
I suspected that's what bothered you, and I'm not upset with you, Don. I want you to know that I'm not cross with you, but and I'm very passionate about free speech issues also, but I don't think it's quite as bad as you're describing it. I guess yes, it is censorship in the sense that anytime you stops speech. It is by definition censorship. But here they're saying it's because they have a policy of not allowing people to advertise crimes on their site. Doesn't that make a difference to you?
No, I don't think that it does. I don't think it's advertising a crime. I mean, advertising in the sense, I don't think people are making paid posts related to this, or I certainly haven't seen them.
Say that again?
I don't think people are advertising on Facebook in the sense of creating sponsored posts or paid posts to show up on people's pages to advertise these events.
Well, I'm just proceeding on the assumption that it is in fact illegal to have these gatherings. That's what the premise is. So if that is true, what is the difference between that and advertising, to get together and beat people up, or, let's go set a building on fire and use Facebook for that? What's the difference except, the severity of the crime, but isn't it still the same basic purpose?
Well, certainly it's severity. And I mean, I have some doubts as to whether these regulations or, government proclamations are valid. Of course, I was just reading a case out of Pennsylvania this afternoon that seems to say that they are. But I think that there's a big difference in terms of certainly the severity and the consequence. I mean, if people are all voluntarily gathering together to have a peaceful protest, I think that's very different than everybody gathering together to go light buildings on fire or beat somebody up. These people are
only in the way we
gathering on their own free will.
Severity, but then if we agree that Facebook, that it's not a terrible policy to ban ads that are about gathering for committing crimes, what you're advocating is that Facebook is should be in the position of judging how bad the crime is. Don't you think that would be a pretty difficult policy for them to grapple with? There's a whole, the whole spectrum of crimes is quite vast and be pretty difficult to be making these fine distinctions.
I think you've flipped the topic on its head there, Jeff, where I think that the issue is whether Facebook should be deciding which political speech it's going to ban and which political speech it's going to allow. Whereas you're trying to frame the issue as which crimes it should allow or which crimes it should ban. I think it's a different framing of the issue.
It's both. I mean, the distinction they're making is the speech they're banning. They at least are clear about it. Is the speech they're banning is when it's advertising the commission of a crime.
Well, like I said, I disagree that it's necessarily a crime, and I disagree that it's Facebook's job to prevent certainly nonviolent protests.
Yeah. Well, it's a policy that they've decided is best. They actually have other kinds of censorship going on that I think is a lot worse. For example, if people are spreading misinformation about COVID-19, they're deleting it, or in some cases they're diminishing the visibility, or they're adding warnings about it. And I think that's worse because in that case, it's clearly an opinion. Here they're using third parties to make these decisions. Are you familiar with what I'm talking about?
Yes, and we've seen this before, and I think we've talked about it before, actually.
Well, I have a terrible memory. When did we talk about it? 10 minutes ago?
No, probably a year or 2 years ago or something.
Oh, okay.
In terms of social media sites and their, possible liability for things that they post or refuse to post.
Oh, yeah.
I mean, the bottom line, I think, comes down to the fact that legally, anyway, that they are, they're private companies and they're providing a forum for people to share things. So they don't really have any legal obligation to either post anything or to censor anything.
Right.
So it really comes down to what the company wants to do in its discretion. And I think
right.
it's
they do what they think is best for their company, and they're also under pressure too, to avoid regulation. They sometimes have to comply with what people are asking them to do.
Yeah, I think it's interesting to see the choices that they're making.
Mm-hmm.
And we may disagree with them, but I think that they're choices they're allowed to make, at least legally. I may disagree morally with a lot of the things that Facebook does, and I may disagree morally with a lot of things the government does. So that's,
Right.
I'm able to distinguish that since I have a degree in philosophy.
Right. Are you familiar with 5G technology and the risks or alleged risks associated with it, the hazards of it?
I have a passing familiarity with that. I've seen people allege that 5G can get them pregnant, and I think that that is a very serious concern that I'm worried about getting pregnant myself from passing by one of these 5G towers. So, the people who post these things have me very worried.
Right. Well, I don't know much about it, but I'm aware that there is controversy about it. There are people who feel very strongly that being close to these towers causes cancer, this and that, so forth and so on. And that's one of the things that Facebook censors is what they call conspiracy theories about 5G technology. And I think that is a very weird thing to censor.
Yeah, that's certainly. I mean, again, it's interesting the choices that they're making. I mean, I certainly have heard some of the, seriously, some of the conspiracies. I don't actually think anybody believes they're going to get pregnant from a 5G tower. But yeah, I mean, there are always concerns about new technologies, especially when they're widespread in society. I mean, there was a concern for a lot of years, and still maybe it's censored from my view since Facebook holds it out. But the cell phones themselves are, giving people brain tumors or things like that.
Yeah, I mean, and who's to say what's a conspiracy theory? Why can't you be wrong, about something, perhaps with no bad intentions,
Sure. I mean, they don't seem to censor out dissent with respect to global warming. I mean,
yeah.
I see people with posts on both sides of that and many other issues.
Right.
That some people think that the other side is just absolutely crazy and shouldn't have a voice, and Facebook doesn't censor those.
Right. So you see, I'm being consistent, but Facebook isn't. In other words, I like, or at least I don't mind their policy regarding these possibly illegal gatherings, because it's not a ridiculous line that's being drawn. But in these other instances, they aren't making the distinction between legal and illegal where the line is. So I would rather them do that across the board. Fraud is illegal. Defamation is illegal, so forth and so on. Just stick with that. But you should be allowed to have wacky opinions, right?
Absolutely. People should be allowed to have wacky opinions. I think that it's very difficult for an entity like Facebook to be in the position of judging what is legal or illegal. I have plenty of clients who claim that their conduct was perfectly legal and the government claims otherwise, and now we're in court fighting about it. So I'm not sure it's Facebook's job to determine what is legal or illegal. And certainly with respect to these protests around the coronavirus thing, I have doubts, and I think a lot of good lawyers have doubts about the government authority and where that line is drawn, and whether people should be allowed to protest. Whether, I think it's a separate issue from, agreeing with the lockdown or whatever. I think that it's a separate issue to question the government's authority related to stay-at-home orders. And certainly, I think people have a First Amendment right to go out and protest if that's what they want to do.
Right. All right. So another legal issue that's in the news now is Michael Cohen, who is Donald Trump's former attorney, and he was known as the Fixer because he was known to straighten out a lot of murky situations that the Donald got himself into over the years. He is being released from prison early due to the coronavirus situation.
A lot of people are.
What's that?
A lot of people are being released early right now.
Yeah, I guess that makes sense. And the news came out that he is going to be releasing a book sometime before Election Day that they're calling a tell-all book. And Trump's enemies in particular are salivating at this prospect. But what I'm thinking about is the concept known as attorney-client privilege, which I think might limit what Michael Cohen can get away with this book. So can you tell people what is the attorney-client privilege and what is the purpose of it?
So the attorney-client privilege is designed to facilitate candor between an attorney and his or her clients. It's basically that whatever somebody tells me in my capacity as their attorney, which is actually defined very broadly, it doesn't mean there has to be a retainer agreement or anything. Somebody comes in for a consultation or we talk on the phone and they tell me something, I have to hold that in confidence. I can't, it's not my place to reveal that to anybody, certainly not to a court or to any government official. I am prohibited from turning around and, telling the police what somebody told me. There are some very limited exceptions if somebody's planning to commit a serious crime, but those aren't really what we're talking about here. But it basically, you tell me something as a client, I can't go out and tell anybody about it.
Well, I'm not sure I buy it, but one of the arguments I've seen actually is that the exception for committing a crime might apply, meaning that attorney-client privilege won't apply because Trump and Cohn were conspiring to violate election laws in connection with the hush money that was paid to Stormy Daniels. Now, I've always thought this was unfair and just downright ridiculous, actually, to call Trump a unindicted co-conspirator simply because Michael Cohen said that Trump conspired with him to commit a crime, and Michael Cohen chose to plead guilty. A court of law, Trump never had an opportunity to defend himself. So how do they decide whether or not, it was done in connection with committing a crime? So did Donald Trump commit a crime just because Michael Cohen said he did and because Michael Cohen decided to plead guilty? Well,
no, and President Trump has not actually been charged with any crime related to these things. So you're right. He hasn't had the opportunity to go to court and, show that he's, put the government to the test to make them prove that he's guilty of something. So, I mean, the crime fraud exception does apply if an attorney and client are conspiring together to commit some sort of a crime. And those types of communications, the government could force, one or both sides to, open up and talk about those conversations. Of course, the question is, how does the government actually force somebody to do that?
Yeah, exactly.
If I'm not going to talk, then I'm not going to talk. You can lock me up and hold me in contempt or do whatever you feel like is appropriate, but I'm not going to talk.
Right. Well, not only you can't force them, but what justifies taking that first step? Because, in other words, if you're compelling somebody to talk, then you're spilling the beans. So what is the first step to justify making people spill the beans if there's never been any trial? How do they make the determination that they might have been conspiring to commit a crime?
Well, based on other evidence, it's not going to be based on their statements. I mean, that's sort of a corpus delicti issue of that applies generally in crimes as to, there has to be some evidence of a crime other than the individual statements. If I walk into the police station and tell them that I committed a murder, I mean, they can't convict me of murder based on that statement alone. If there's no body, there's no tools, there's no, other evidence of a murder, they don't get to charge me with it.
So they would have an evidentiary hearing? Would that be the term?
Sure. They would generally have an evidentiary hearing. It would largely be done in camera, not an open court, to determine whether there's grounds to violate or to set aside an attorney-client privilege and make somebody testify. With respect to the Cohen situation, this is something that's quite different from that circumstance, though, where it's Cohen who wants to talk. The government isn't trying to force him to talk at this point. He wants to talk. And that the
privilege, so to speak, is Trump's, is it not? I mean, Trump can assert attorney-client privilege. He doesn't want Michael Cohen to spill the beans.
The privilege belongs to the client, and the client has to waive it in order for it to no longer be present.
Right.
What's happening now, though, I mean, this was an interesting issue a year ago when Cohen was testifying before Congress and when Cohen was, taking his own plea deal and making that all work out. Now the issue is, what's the consequence if he divulges those kinds of client confidences? He's already been disbarred.
He's already been disbarred. That would be the normal penalty. But couldn't Trump file a civil lawsuit?
I did a little bit of research on that this afternoon, and I don't see any precedent for that. It doesn't mean it can't be done. I mean, you can sue anybody for anything and let the courts sort it out. But generally, I mean, the consequence of violating attorney-client privilege would be some sort of state bar sanction up to and including disbarment.
Right.
That's not an issue. He's already been disbarred. So I don't know what, I mean, the bar can't do anything to him for revealing that stuff.
Yeah, I hear you.
I haven't seen anything that makes it a crime or would make him criminally liable for violating attorney-client privilege. Certainly there could be some sort of civil cause of action. I haven't really thought much about what the cause of action would be. The Trump administration.
What about prior to publication? Could Trump get an injunction stopping publication?
I think that's likely to be one avenue to run to court and see if you can get a preliminary injunction to prevent the book from being published, at least until there's some further judicial ruling. I think you could analogize the attorney-client privilege to like a non-disclosure agreement. I'm not sure if there ever was an official non-disclosure agreement between the two. I would assume it wasn't necessary, right? I've never signed a non-disclosure agreement with a client because we have attorney-client privilege.
I think that's a reasonable assumption.
So it's fascinating that, I mean, what do you base your cause of action on? The privilege? I'm not aware of any case where somebody sued an attorney over a prospective violation of attorney-client privilege. Doesn't mean it can't happen.
Well, Donald Trump is known to do unprecedented things, and he's also been very litigious through the years.
Sure, it's been Michael Cohen who's been at his side doing that for him. So.
Yeah, I know. This could be an interesting situation. Now, another exception to the attorney-client privilege is if whatever the discussion wasn't really related to legal services. In other words, you hire an attorney to do a contract for something in business, and then the client happens to mention that he beat his wife. That would also be an exception, correct? Because it was not in connection with the legal services?
There are, I'm not sure I would call it an exception, but the attorney-client privilege does not cover things that are outside of the legal framework. Your example, I would think is still within the legal framework. I mean, I'm a criminal defense lawyer, but if somebody were to ask me, say, talk about beating their wife or whatever, certainly that's covered under my scope. But if they also ask me about a contract issue in their business, I might say, I'm not going to handle that, but I'll refer you to somebody who will.
No, but I'm talking about, in my hypothetical, they clearly have not retained you for services related to wife beating. It's about some contract in business, just in this hypothetical. And just in the course of conversation, they mention it. It has nothing to do with it.
As I mentioned in my description of the attorney-client privilege, it covers non-clients. It covers all kinds of things. It's very, very broad. Mm-hmm. So I would say that any conversation I have with somebody who's a client or a prospective client, anything that hints on a legal issue, that's privileged. Like I said, if I'm representing somebody with respect to a criminal issue, and then, I'm clearly not retained related to a business thing, but they own a small business and they want to ask me about a breach of contract issue. Right. I may refer them to another attorney for that, but I still can't go out and blast, say it's the owner of a pizza joint or whatever. I can't turn around and go on Facebook and say, oh, the owner of this pizza joint's having a contract dispute with his landlord, even though I'm not representing him on that. I'm representing him on, a domestic violence case.
Well, yeah, it's not something
I certainly couldn't blast the domestic violence case, but I also couldn't blast the contract dispute.
Well, I'm not saying it would be advisable or laudable or anything like that. I'm just questioning whether or not it's really covered by the attorney-client privilege. I know I'm not an expert or anything, but I've read up on it a bit, and I saw that Bruce Cutler, who was John Gotti's attorney, that was an issue there where Gotti claimed that Cutler just represented him for everything. And so there was, I forget exactly, what all the issues were, but that was, one of the arguments that were made, and I don't think it held up.
Well, related but broader than the attorney-client privilege is a duty of confidentiality, which is separate, but it's related and it's much broader. Whenever I talk about a case that I'm working on, I will never mention a client's name. In fact, I consider the fact that I represent a particular individual to be covered by confidentiality obligations. So
Right.
if you come up and ask me, hey, do you represent Sarah Jones? I'm not going to tell you that. I may talk about her case in the abstract, but I would never tell you that I'm talking about her case, and I would never admit that I'm representing her, even though that's very likely a matter of public record, right?
Right.
I've been in court for her. It's on the record. You could go get a docket printout that has my name on it. I'm still not, I'm not going to tell you that I represent somebody. In fact,
Okay.
I have represented my wife's friends and not told her because it's just not,
Well,
and
you're
I
an
still wouldn't tell you the name.
believe me, I'm not encouraging this behavior. All right. So I was just on your Facebook page right before we started, and I saw that you posted something about somebody who was arrested for drunk driving, got released, and then just maybe 5 hours later or a short time after that, got arrested for drunk driving again right after he was released. And one of your Facebook friends said, "Oh, I thought they usually hold people for longer than that." And you said, "Not always. Sometimes they do, sometimes they don't." And I said, I just replied, you probably haven't seen it yet, that I think people who are arrested for drunk driving should be released as soon as possible. And as far as the possibility of them driving drunk again, that concern can be addressed by impounding the car for, say, 12 hours or for some period of time. But a person shouldn't be deprived of liberty just because they've been accused of drunk driving. What do you say?
I say that different crimes are all treated differently, and DUI is treated very differently than a lot of other misdemeanors. In fact, in the currently in force Chief Justice's orders of the California Supreme Court, they've said that, basically everybody's supposed to be released without bail, and there's a list of exceptions, which include serious crimes, violent crimes, and DUIs are on that list. That various police departments and local counties, if they want to hold somebody who's accused of a DUI and enforce their normal bail schedule, they're welcome to do that. We often joke about the DUI exceptions to the Constitution in this and many other contexts. But the reality is, Jeff, that when somebody's arrested for a DUI, they could be held pending bail, or they could be held until they're able to see a judge for much longer than the 5 or 6 hours that is standard. So
well, that's part of my argument, actually. I'm not saying they should be brought before a judge, but if there's some reason to do that, then they can do that. If they're not doing that, then release them, because being drunk is not a crime. It's just only drunk driving is being a crime. It's not necessarily particularly dangerous. There is a crime, it's usually called drunk and disorderly conduct, when somebody is so inebriated it's unsafe to be in public, even, as a pedestrian drunk. If that's the case, then they could be charged with that too. But if they're just too drunk to drive, but not too drunk to be a pedestrian, then how does that square with the Constitution? Because obviously anybody who's been arrested could be innocent, and there's no way to give them back that time if you keep them in jail just because they've been accused.
Sure. And once they're arrested, the government could hold them until they either pay bail or until they see a judge. The government would see it as an act of mercy that generally they're letting people out far sooner than that, and on their own recognizance, with a citation to appear in court 3 months later. So it's not, and I think that they're probably right. I mean, most departments are going to hold somebody. Sometimes they'll give them a subsequent breathalyzer to see, once they come down under, 0.06 or something. Different departments have different, sort of guidance on these things, and I'm not sure any of it's written anywhere.
Well, what's wrong with my solution? I think my solution strikes a nice balance between these competing considerations. On one hand, we don't want people driving drunk. And on the other hand, we don't want to deprive a human being of liberty if we're not even sure they committed the crime. So my solution is impound the car for a few hours.
Well, you're not sure anybody's you're not sure anybody who's been arrested has ever committed the crime. So we should let all the murderers out ASAP without bail.
No, unless you're going to take them before a judge, either do it or don't. Don't say we're going to hold you because we could take you before a judge, but we're not. Right? People who are arrested for murder are arraigned, right, before a judge, are they not?
Generally within 72 hours. Right now, during this crisis, that's been extended to 7 days that people can be held without seeing a judge. And I certainly wouldn't want my DUI client held in custody for 7 days before they see a judge. I'm happy that they're released on their own recognizance so that they can come to my office.
With this weirdness that's going on now. I'm saying that whether or not somebody is going to be brought before a judge should determine it. If you're not going to take the guy before a judge or the woman before a judge, just let them go.
I agree that people should be let go much faster, but I think the response that you're going to get from government officials is that it takes time. They're being they're being processed. A sergeant is reviewing it. They're deciding whether they're going to release them or whether they're going to keep them in custody till they see a judge. And then once they finally make that decision 5 or 6 hours later, and they've deemed that they're not going to be dangerous to be released, then they go ahead and release them.
Yeah, well, what you're talking about is fibbing. I understand that sometimes, depending on where it is, there may be a lot of arrests and it may take time to process them all and so forth and so on. I'm not talking about that. I'm talking about where they're deliberately holding DUI arrestees because of the offense until
it is a general policy in most departments to hold 5 or 6 hours before letting them go. And I think that is a problem. I agree with you that it's a problem.
Finally, those are the words I was looking for. I agree.
But I'm not sure there's anything to be done about it because the government response is going to be, we have the right to hold them until they can see a judge or until they post bail. If they'd rather post bail and get out earlier, they're welcome to do that. And in fact, when I get calls in the middle of the night or otherwise of a family member saying, hey, my boyfriend was just arrested for DUI, should I bail him out? I say he's going to be released in 5 or 6 hours anyway. You want to spend the money on bail? Probably not. And similarly, like you said, they should go impound their car for a number of hours. That's very expensive. So I would rather save my clients the expense.
It doesn't have to be.
Well, somebody's going to pay for it when that tow truck shows up and then they store the vehicle.
Well, they have to sometimes they have to tow it anyway, right?
Usually they don't have to.
Right. And if they don't have to, then maybe they can just put a boot on the car or something that's not quite as expensive.
Yeah, what I'm hearing, Jeff, is that you as a taxpayer want to pick up the tab for all these towing and storage charges, and that would be a fascinating move.
Well, maybe the arrestee pays for it if ultimately found guilty, but doesn't pay for it if found innocent. How about that?
And the local towing and storage yard is going to wait for a year till I resolve the case to decide who's going to pay them?
We can sort that out. And I already said we can maybe bypass that whole thing by just putting making the car immovable where it's parked. That's probably less expensive than towing.
Very often in sort of low-level cases where it's safe to do so, the police will leave the vehicle parked, in a parking lot or on the side of a road. And most of the time when they're doing that, I see it as an act of mercy because they could tow the car. They have the legal right to tow the car in every DUI case, and it just creates more of a hassle for the defendant to go get their car.
I bet more than 50% of police departments in this country have enough space in their own parking lot for however many people were arrested for drunk driving that night.
I have never heard of a police department having a vehicle towed to their own parking lot. They all have contracts.
Well, I know.
For some reason, you want to go behind the scenes in the bureaucracy and who's slipping money to whom.
I'm a problem solver. Remember, I want the courtrooms mic'd, and I want cops to hold the car in their own precinct's parking lot. Put me in charge. I'll straighten everything out within a week. Guaranteed.
Right. And then everybody's going to sue the police department for damage that allegedly occurred when the car was parked in their parking lot.
All right, Don, I don't know if we made any sense this week, but I think we sounded better than ever because we both have microphones, and they're identical. How about that?
Twinsies.
All right, Don, anything else you want to say before we call it a podcast?
No, I think we're good, man. Thanks.
All right, thank you. take care, and we'll do it again maybe next week.
Sounds great, Jeff. Thank you.
All right, Don. See ya.